Danny Kruger.
Thank you very much indeed, Mr. Deputy Speaker. Let me start by saying how much I support the objectives of the bill, and I pay tribute to the government for the very significant improvements on the status quo that the bill represents. There are, of course, some practical issues which have been well rehearsed on this side of the House with its operations, and as my right honourable friend, Member for Newark, said so well earlier, what really matters is whether it will work. And what working looks like is being able to detain and remove sufficient numbers of migrants quickly enough, illegal migrants, that they decide that the journey across the Channel is not worth it. And that means ensuring that we have the capacity in the system. And I recognise the progress the government has made to improve capacity, but I think, as my right honourable friend says, we have significant concerns about the system getting gummed up with legal claims that are still allowable under the bill. And we're also concerned about the continued operation potentially of Rule 39 orders from the Strasbourg court. But, Mr. Deputy Speaker, these practical problems, which I think are real and need to be addressed in the further stages of the bill, derive from a fundamental point of principle. And I really do welcome the noises that are made in the bill that would gladden the heart of my honourable friend, Member for Stone. It's rather like Bill Cash bingo in this bill. There's notwithstanding this, and there's supremacy that, and sovereignty the other, and it's all extremely welcome. Nevertheless, these words do not apply in the crucial places. It still rests the right of individual claims on international law, on the case law of the European Court, and of the operations of the ECHR in our own country. And let me say quickly, Mr. Deputy Speaker, I'm not calling at this stage that we should depart from the ECHR, although I think we could do that. In response to the honourable member for Hodge Hill, who just spoke, as if we, leaving the ECHR, would be departing from the honourable and ancient British tradition of liberty. Of course, as he implies by his speech, we would be returning to it if we were to leave the ECHR and rest our liberties on the statutes of Parliament and on the common law of our courts. But nevertheless, if the European Court were to disagree with the actions of the government and they issued a substantive ruling to that effect, then we begin a process of conversation with them about that, and we decide how exactly we might comply, or indeed, if we had to, depart. Let me turn, Mr. Deputy Speaker, to the Supreme Court judgment from last month, and I think it is pretty important, very important, that we try and analyse the implications of that ruling. It is true, as my honourable friend, Member for Stone, said, that the Supreme Court ruling does acknowledge explicitly that UK law is supreme over international law in one of the cases that it considered. It makes this point in principle. But except in that one case, it doesn't make it in practice. It ruled against the government on grounds that derive from European and international law, as well as other domestic laws. So the court suggested that, in practice, that international law trumped domestic law. And having done that, it then inserted itself into foreign policy. It presumed its right to judge a foreign government. It said it should decide for itself whether the Rwandan government's undertakings could be relied upon. It essentially gave itself special investigatory powers to make judgments of another country. It described, rather patronisingly, the inadequacy of the Rwandan system, as if that's any business of a British court. And while it totally disregarded the UK government, it said the executive of the UK enjoys no constitutional prerogative in this regard. But it did give what it called particular importance to the opinion of a United Nations agency. Yeah. So it asserts itself into foreign policy. It draws down the authority of international law and international global agencies. Where in its understanding is the role of the UK government? Where is its understanding of the role of this place, Parliament, which sets our laws? And I want to just reflect briefly on what the rule of law means, because the phrase is invoked constantly by critics of this bill and of our Rwanda policy, as if international law trumps domestic law. It is not the case that the rule of law implies some kind of hierarchy of law ascending from, parish council, local bylaws, up to the global law. The rule of law means the supremacy of Parliament and the operation of the common law, of case law, made by our courts. And my honourable friend, Member for Stone, cited all the distinguished jurists, Hoffman, Bingham, Denning, not Hale, didn't mention, but did mention Reid. Did mention Reid, the President of the Supreme Court. International law is, of course, important. I totally recognise its enormous value in keeping the peace in the world and enabling us to deal with other countries, but it applies to the international plane. And let me touch briefly on human rights law, which has been mentioned as well. There's an assumption that the Human Rights Act has some kind of superior status in our law, and I recognise that is often seen to be the case, but that is problematic. The rights and liberties of individuals, of citizens and of foreign nationals, whether they're legally or illegally here, those rights and liberties are properly protected by statute and case law. And let me finish by saying, Mr Deputy Speaker, I regret we've got an unsatisfactory bill. I can't undertake to support it tonight. I'd hope the government would agree to pull the bill and allow us to work with them and with colleagues across the House to produce a better bill, one that respects parliamentary sovereignty and also satisfies the very legitimate concerns of colleagues about vulnerable individuals. I think we could do better on safe and legal routes, for instance. We should be working together with other countries to design a system that respects the sovereignty of Parliament and the legitimate rule of independent nations.